and useful processes, machines, manufacturers, compositions of matter, trade secrets, which is very important to me. It's getting much more press and notoriety these days, and I'm going to talk about trade secrets quite a bit, particularly in light of an act from 2016 called the Defend Trade Secrets Act, which has brought it to the forefront, trade secrets in IP litigation, as well as the issue which many of you might know in terms of or relating to the FTC and non-competes and the action that's going on there. And what I'm going to say is the reduction, maybe even potential elimination of non-competes in traditional employment agreements. Trademarks, designs, symbols, names, and images that we use in commerce for our goods or services, and then copyright. So we're going to, if there's any confusion on any of these, what's what, we're going to try to dispel all that today. So, Coca-Cola bottle, zero, classic, and diet. How many types of IP do we think are in this bottle? Actually, at least 6 in terms of the bottle itself and what's inside. Utility patent, for example, on the cap design. You can get a design patent on the actual shape. Trade secret, one of the most famous trade secrets probably in the world, is the recipe for Coke. Trademark, the logo, the famous Coca-Cola logo. Trade dress in the bottle shape itself, and then copyright in terms of the text that's on the specific label. So, 4 main types of intellectual property: patents, trade secrets, trademarks, and copyrights. We're going to talk about patents first. I have a quote here from the World Intellectual Property Organization. Global intangible assets, that's what we refer to intellectual property in the legal world and also in the business world. Intangible assets held by firms worldwide are worth 61.9 trillion in 2003. So the upshot here, the takeaway, is that over the past 20 to 30 years, intangible assets have become more important to businesses than ever versus physical assets, the printing press in your facility, the manufacturing equipment in your facility. The intangible assets are more and more important to businesses. That means that we have to be very careful and diligent in terms of how we organize, protect, and enforce those assets. Patents. That right there on the slide is a picture of a patent. Patent is actually a physical document that the patent office gives you, issues to you when you get a patent. A patent is, this is important, it's a legal right to exclude others from doing specific things, and this is laid out in the patent statute: making, using, offering, for sale, selling, and importing into the United States the invention that is claimed that was issued to you in your patent. Patents last 20 years from the earliest quote unquote priority date of the patent. That's a legal term, legal issue that you let your lawyer worry about. There's also things you can get that extend the term of the patent depending on how long the patent office takes to examine and give you a patent. So what a patent, we're going to talk about what a patent is and what a patent is not. A patent is a time-limited monopoly to the invention that was granted to you by the U.S. Patent Office. And the U.S. government, and this is in the Constitution, it's a trade-off. Okay, we're going to give you 20 years on a monopoly in your invention, and in exchange for that, after those 20 years are up, anyone in the world can use that invention. That's the trade-off, that's the exchange contemplated in the Constitution. It is a negative right to exclude others from practicing the invention. This is important. It's not actually an affirmative right to practice the invention. And I'll explain that in a bit more detail in a moment. Examples: processes, mechanical devices, chemical compounds like pharmaceuticals, computer hardware, not necessarily software, and we'll talk about that. New and useful improvements of the same. So you can have a patent on 4 or 5 old known elements if you put them together in a unique, new, useful arrangement. What a patent is not: a patent does not provide you the right to sell a certain product or practice a certain method. If you have a patent on your product, that doesn't mean that, oh, well, I can sell this and not infringe anyone else's patent. No, a patent is your right to exclude other people from doing what is claimed and protected in your patent. So as the second bullet there says, at the last bullet, having a patent covering a product or method does not mean that you can offer products or services without infringing the rights of someone else. When to choose patent protection. This is particularly important when you're thinking about patents versus trade secrets. When excluding competitors is important, that is when you want to think about patent protection. When your product is easily reverse engineered or copied by competitors. If you have a product that you put out into the market and it's easy to reverse engineer or copy, then you can't keep it as a trade secret. You need to get a patent on it and protect people for the term for 20 years from doing that exact same thing. How to obtain patent protection? Well, we prepare and we file a patent application with the U.S. Patent Office. And then there's a lot of different decisions that go into that. Typically, it's important to use a patent lawyer or someone that is experienced in how to do that, because the Patent Office procedures are very confusing and they send back a lot of documents to you, and it'll be confusing on how to actually deal with those documents and those what I'm going to call objections or rejections to your initial filing. You have to figure out how to respond to those different communications from the office. What cannot be patented? So there's a section in the patent statute, which is section 101, that lays out certain things that you can't patent. You can't patent the laws of nature, natural phenomenon, or abstract ideas. And there's a lot of legal jargon that goes into, for example, abstract ideas. But for example, you can't try to patent the law of gravity. That's already out there. That's been done. Living matter, a mushroom, a tree, a fungus that's already known. You can't get patent protection on something like that. There are exceptions, which are, for example, here, living matter, except living matter that's been altered to have characteristics it would not have naturally. So if someone comes up with an interesting biological twist on living matter, then that could be patentable. Shannon, I think it's worth saying at this point, I just thought of it, that if everyone is okay with it, I'm happy to circulate a copy of this PowerPoint deck to everyone listening so that people can use it as a future reference, if that would be helpful.
Yes. Yep. After the webinar, we'll send out kind of a follow-up thank you email, and we'll include a link to Brad's presentation just so everybody can go back and reference.
Basic process, I kind of alluded to this already. You have an invention, you conceive of an invention, you reduce it to practice, that's a legal term of art that's in the statute. That means one of two things. You actually create it in the laboratory or in your garage or in the facility or in your office. Or reducing it to practice could also mean, all right, I'm going to think about it, I'm going to write it down in a white paper or write it down in a patent application. That could also be a constructive reduction to practice. We prepare and file an application. There's modest filing fees from the Patent Office, a couple $100, especially for a smaller business, that the Patent Office charges. There's patent office actions where you get selected or you get allocated a patent office examiner. They look at the patent application, the invention, and they say yes, no, and then they respond to you, with rejections. This has already been done. This hasn't been done. You should amend your application this way, etc. And then ultimately, hopefully, you get an allowance from the patent office and you get a granted patent. Interestingly, depending on the technology of your patent, it could take 1 to 2 years. It could take 3 to 4. For example, software patents that's a very, what we call an art unit, a very crowded technology unit at the patent office. And software patents, computer-related patents, can take quite a few years to get through the office. Different types of patents. The main patent, the primary patent, I would say 90% of patents are utility patents. That is a patent on how something works, a mechanical configuration. For example, this golf cart up here, that has all sorts of different utility patent configurations in it. Design patent would be actually a patent on the look or specific configuration um, of of a product. Plant patents are not that common. I've actually never dealt with or done a plant patent. Those are very rare, but I thought I would just throw it in here in this presentation just so we all know that there's three different specific types. Trade secrets. All right. Many of us, if not all of us, have probably heard of the term trade secret, but what is it? What is a trade secret? Well, it's any information protected from disclosure by quote unquote reasonable measures and valuable because it's not generally known or readily ascertainable, for example, by reverse engineering, by others. Classic examples are manufacturing settings, source code, software algorithms, customer data, testing, research and development data, ingredients, materials, formulas, etc. What a trade secret is not. Inventions that are publicly disclosed in patent filings, for example. Anything that's publicly disclosed. Once you disclose a trade secret, it's no longer a secret. So the real value in a trade secret is the fact that no one else knows about it, and it imparts business value, technology value to the company. When to choose trade secret protection, for example, versus patent protection, when the cost or timeline for patenting is infeasible. For example, again, like I said, patenting could take 3 to 4, 5 years. It can be an expensive endeavor. It could be $50,000, $100,000, depending how much to and fro occurs between your patent lawyer and the patent office. When long-term secrecy rather than eventual public disclosure of core technology is vital. Classic example is, again, the Coke recipe, the formula for WD-40. They would never put those things in a patent because after 20 years, they disclosed, then what would Coke do? What would WD-40 do? When the innovation is not patentable, there's certain things, such as software algorithms, on their own that cannot be patented, or would at least would be very difficult to enforce, for example, against potential infringers. Manufacturing processes, what I see in my practice that companies most often keep as trade secrets is manufacturing specifications, temperature, humidity, pressure, things like that that don't really inure to patent protection, but are super, super important to how a product is made and the specific, crown jewels, so to speak, behind the technology of a company. When the technology is hard to copy or reverse engineer, how do we obtain patent protection? Well, I'm sorry, trade secret protection. Keep it secret is the first thing you want to do. And identify and record your trade secrets. Make sure you actually know what they are. That's the best way to actually keep them secret. Keep a list of some sort, know what your trade secrets are, have them written down inside the company. We have a whole, at Mintz, we have a whole program where we work with our clients and potential clients to help them better manage their trade secrets, help them keep their secrets inside the company and prevent them from leaking outside. That's a different presentation, but what we call that reasonable measures. You want to keep your trade secrets secretive and make sure you take reasonable measures to make that happen with confidentiality agreements, need to know access, and other types of restrictions. So I just thought this was interesting, something interesting to think about. Every patent begins its life actually as a trade secret. So when a new technology is conceived, when a new method of manufacture is designed or developed by an engineer at the company, there's a choice to be made. Do we keep it as a trade secret, or do we try to get a patent on it where it'll ultimately become public? Here's a slide that just kind of distinguishes trade secrets versus patents. How can trade secret owners lose their rights or forfeit their rights? Well, by not sufficiently identifying and what I'm going to call registering or recording, listing their secrets, and protecting them using reasonable measures. Number one, no trade secret program or no trade secret protocol to identify and actually list what your trade secrets are. Lack of reasonable measures is another way, and then inadvertent disclosure due to lack of identification. If you don't know what your secrets are, they could be or more susceptible to actually leaking outside the company, or someone actually mistakenly at a conference or in talking to a third-party vendor disclosing them without even knowing it. And just so you know, the reasonable measures I keep referring to, this is actually language in the statute, the Defend Trade Secrets Act, where it's a requirement. There's 3 different prongs in terms of what establishes a trade secret, and taking reasonable measures, quote unquote, to protect the technology or the proprietary information from disclosure is requires reasonable measures under the statute. Any questions so far? I can't see the chat because I'm in full screen mode.
We don't have anything that's come in yet.
Okay, thank you. Trademarks. Here we go. That symbol right there, the R with the circle around it, that denotes that you have a trademark that's federally registered with the U.S. Patent and Trademark Office. That's when you can use that. A lot of times you'll see a TM. That means absolutely nothing legally. You see people put that in there to kind of suggest, hey, this is my trademark, but legally TM means nothing. SM for service mark also means nothing. This R, that is the actual symbol for federally registered trademark. And we're going to talk about that now in more detail. What is a trademark? A trademark, different from patents and trade secrets, is used to establish the brand, your company name, with the goods and services that you sell, manufacture, and sell. Words, symbols, phrases, logos, or other designs that distinguish your goods or services from those of others. Similar to a patent, a trademark provides the exclusive right to use the mark in commerce for the class of goods or services that you obtain protection on for that mark. So when you go to apply for a trademark, the patent office is the patent and trademark office is going to ask you, okay, you want to register mark X. You have to select what goods and services that mark X is going to be affiliated with. So what a trademark does not do is give you a right to exclude others from using the mark you have on unrelated goods and services. For example, Apple cannot stop an orchard from advertising apples for sale. If that orchard was selling computers under the name Apple, that's a different story. Indicate the source of goods and services. That's what trademarks do. Here are, in my view, 4 fairly famous logos, trademark designs: NBC, Gmail, Starbucks, and Apple. So we can see the value that a trademark can really drive for a company. These are 4 examples of very highly valuable trademarks that as soon as you see that, you know exactly what goods and services are associated with that, with these 4 what we call design marks.
Hey, Brad, if we've got a second, we did have a question that came in.
Okay.
Um,
If I go out of full screen,
You're fine. I can read it. It says, the slide says confidential property. Assuming we receive them, can we share them without inviting a lawsuit?
that's all the slides. You know what? They do say that. Yes, that's fine. You know what? I'll remove that.
Okay. Good call.
I think our Mince's default kind of template just has that on there. If we're presenting to clients or potential clients, that's a good question. It's a really good question. I don't know who asked that, but excellent question, and I'll pull that off of there for sure.
Thank you, Ellen. We appreciate that.
Okay. Are you seeing the PowerPoint again?
Yes.
All
Yep.
right.
You can just go back into your full screen. There we go.
I think we were here. Can you see the Pringles can?
Yep.
Awesome. Go. What can a trademark be? Words, logos, designs, letters, slogans, etc. So importantly, what cannot be used as a trademark? Well, a mark that's confusingly similar, that's the standard for a trademark under the trademark statute. That is kind of that's what the test is. Okay, is this mark confusingly similar to a trademark that's already out there and that exists? Marks that are deceptive, suggestive of a false connection, those are both problematic and cannot be used as a trademark. Marks that are functional, for example, the court or the trademark office did not grant Rolls-Royce a trademark on its front grille. It ruled that it was non-functional. And the pink color, Pepto-Bismol, too, interestingly. I can't remember that case. It's been a while. But they said the color was soothing the patients and therefore had a functional relationship. This is kind of the hallmark legal requirement for a trademark, and that's what the patent and trademark office, the trademark examiner will look at when they receive an application. Is it distinctive? And distinctiveness is measured on a spectrum. Some marks are almost automatically qualified as a trademark if they're inherently distinctive. And there's three different terms or types of marks that are inherently distinctive. Fanciful marks, a made-up word that identifies a particular brand, arbitrary marks, and suggestive marks. So fanciful marks, Kodak, Exxon, Pepsi, words that don't exist in the English language. Arbitrary marks, Apple for computers, Camel for cigarettes. Marks that are not distinctive. We call these marks generic marks. Now, there's two types of generic marks, and this is always a fun exercise. Obviously, things like T-shirt for a T-shirt company, restaurant for a restaurant, coffee shop for a coffee shop. The trademark office is not, you're not going to get a federal registration on those types of trademarks or service marks. Interestingly, marks can lose their distinctiveness and become generic. And this can be, especially for a company that's very well known, this can be dangerous. And it has happened to several companies. And you can see some of the classic examples down here below. Aspirin was originally a fanciful mark, and it has become this generic, what we call generic over the years. Zipper, linoleum, escalator, believe it or not, that was a name brand, a company name for a moving staircase. And Kleenex, Xerox is another classic example. Band-Aid, Yo-Yo, and Thermos are all examples of trademarks that were originally fanciful names made up by companies that have since become generic because everyone just associates the good or the service with that particular word. So companies fight very hard and are very cautious about when they reach certain level of notoriety about their brand name or their trademark not becoming associated almost ubiquitously with a particular good or service. When to choose trademark protection? Really, the answer for companies, my answer is always. Trademark protection doesn't require a lot of work. It's fairly economical, a couple $1,000s, including the attorney's fees and the filing fees. You can get yourself a trademark for your business, and it's really important because it can distinguish you, will distinguish you, your goods and services from those of your competitors out in the market. And again, how to obtain trademark protection, similar to patents, you file an application. Process is a bit different, but you file an application, it gets examined by an examiner in the trademark division of the Patent and Trademark Office, and then ultimately you will get a trademark application. You will get an application. There could be an opposition from a similar mark, which you might have to deal with, your lawyer will have to deal with. But 9 times out of 10, in my experience, your application will be granted and you'll get a trademark. Typically, what we do, different from patents, is we'll do a trademark search for our clients before we decide whether to file a trademark application. You'll do a search of the trade. There's a big database on the Patent and Trademark Office website that you can check and search and check for trademarks that are similar. And we have a pretty good idea before we actually prepare and file the application, what the chances are of getting a granted federally registered mark. Interestingly, this last bullet here says obtain common law rights in a geographic area. You can get common law, which is basically law established by the courts, in a specific geographic area by using your mark over a period of time in that area where your goods and services are offered. So say Joe's Pizza in, Allentown, Pennsylvania, which is close to where I'm from. They've been there 30, 40 years. Joe arguably has common law rights in that Allentown, Pennsylvania area. If everyone in that area has come to know Joe's Pizza or Joe's as associated with his pizza, his pizza services in that area, and arguably he would have a good position against someone else who tried to come in to that area and do pizza under the Joe's Pizza name, even without getting a federal registration from the U.S. Patent and Trademark Office. Last but not least, copyrights. And that graphic there is the C that you'll see in books, on photographs, and that denotes a registration with the U.S. Copyright Office. Copyrights are interesting in that rights or ownership in a copyright vests automatically. You actually don't have to do anything technically under the law. It's a work of authorship that's fixed in a tangible medium. Now, that's not natural language, but that's what the statute says. The right to exclude others from producing, distributing, performing, or publicly displaying the work of authorship. Examples include songs, books, artwork, photographs, advertising software, data, etc. What a copyright is not: recipes, facts, short phrases and titles, things that really have no artistic aspect to them. Facts, unless you argue that there's a very unique arrangement of the facts or the ingredients of the recipe, that will be difficult to get copyright protection on. How to obtain copyright protection. As I said, ownership actually vests automatically in the author. The works created by an employee or contractor require works made for hire agreements so that the author assigns ownership to the employee. So if the employee creates a copyright during his or her employment, that ownership will vest automatically in the employee. And the only way it goes to the contractor is if in the employment agreement, there's an actual what we call work made for hire provision in the agreement, which it is the case almost all the time. Register your copyright with the U.S. Copyright Office. This is even easier and more economical than filing and obtaining a federal registration for a trademark. When to choose a U.S. copyright registration. When leverage is needed, in this last bullet, to protect your work from being counterfeited. Again, if this is, it's not expensive, and it's a fairly straightforward process to get a copyright registration. So, for example, I have a cosmetic client that has one product in particular that has become very famous and has been getting knocked off by counterfeit products coming into the United States that look and say almost exactly what my client's product says on the bottle. So we got a copyright registration on the text on that bottle. And using that registration, we've been very successful in getting online platforms like Amazon, Facebook, TikTok, eBay, but using that registration, those rights in that registration, to take down any of the advertisements for those foreign counterfeit products. Copyright owner's exclusive rights. I think we went over this a couple slides. Previously reproduce the work to make copies of it. You have the exclusive right to create derivative works, that is, modify it to an extent. There's a little bit of there's legal issues that get into the scope of derivative works, but you do have that right generally. Distribute copies to the public, perform or publicly display the work. Copyright versus public domain. Under the federal law, this copyright statute, works created after January 1st, 1978, receive copyright protection for life of the author plus 70 years. So that's a long time. It's much longer than trademark or patent protection. So those are the four main types, four types of intellectual property. Now, this next section, I thought it would be helpful, since I'm guessing we might have some business owners, small businesses, maybe larger, middle-sized companies listening in today to talk about perfecting IP ownership. We want to make sure that we've got perfected chain of title. And what that means is that if you're an employer, you have a business, you want to make sure that you own the IP. That because specifically for trade secrets, for patents, those rights vest initially in the inventor or whoever came up with it. So you want to make sure that your provisions in any employment agreement that you sign vests all right and title in that intellectual property to the company. Patent protection. Employment agreement should convey patent ownership to the company. We do this using patent assignments, and the classic language is all right, title, and interest in and to the inventions are conveyed to the company. This is what the employee typically agrees to. It's important, this last bullet here, I hereby assign all right, title, and interest in and to. That's present tense. I hereby assign. We want to avoid language like I will, or I shall assign, or I agree to assign. We want to use present tense language. That's an issue that we see a lot come up, and we make sure that our clients make sure to have that present tense language in there. Trade secrets, again, similar. The employment agreement should assign to the company all inventions, discoveries, etc. The classic language with respect to trade secrets in the employment agreement or the confidentiality agreement is inventions, compilations, discoveries that derive independent economic value from not being known. That's the language we want to keep in there. That's language actually directly from the Defend Trade Secrets Act statute. Trademark rights. Trademark owner is the party that owns the federal registration. So typically the company will be the applicant or the party owning the federal registration. That's where ownership will reside in that situation. If you're an individual, then you'll apply for the trademark in your name, and it'll be the federal registration will be on the trademark office website, and your name will appear there as the applicant and the owner. Trademarks can be assigned just like trade secrets and patents. As I referenced earlier with respect to generic marks, trademark owners should be very cognizant of policing unauthorized usage by third parties. You can use a cease and desist letter to avoid the mark becoming diluted, which means becoming associated with a broad category of products or services that are unrelated to the company, or just very broad in terms of beyond what your specific company actually sells or provides. And I've had this situation come up, not with one of our clients, but a company that sued one of our clients. They had a mark that had become diluted. We made that argument and prevailed. Copyright, this ownership, again, similar to patents, actually automatically vests with the inventor or with the author. And we talked about the work for hire doctrine. I put this slide in here in light of Koffman being related, associated with Binghamton University, thinking that perhaps we've got some audience members today that are using technology that were invented at a university or that they're part of a company that spun out of a university. We've got a whole different presentation on this. There's a lot of different things that go into this, but it's important. The one thing I'll say is that it's important to think about how the rights, the ownership flows when you're using technology that was invented at a university. Many companies start with IP that was research created or patented at a school. And then, of course, there's employee or student agreements between the universities and the inventor, talking about who owns what, how the ownership flows. So we want to understand, again, the takeaway is understand what rights you have, what rights you might need to bring your company and your technology to market, and how to get those rights. It can be a complicated process, but something that we advise our clients on quite a bit. Okay, let's talk a bit about strategies. And I refer to this when we first started today, aligning IP strategy with current corporate vision. A lot of words on this slide. Hopefully it'll be a good reference for folks going forward. Number one, keep open doors open. So resist the urge to ignore certain technology or different product applications. The life of your business can take different turns throughout, even over a course of 1 to 2 to 3 years. Be open to that in light of the market changing, and understand how you might align your IP, your intellectual property, with the direction that your business is going. Understand the need for collaboration. This is important. It's often the case that your business will have to rely on, collaborate with third parties. So think about how, from an intellectual property standpoint, how you're going to do that, the NDAs you're going to enter, the joint agreements, the collaboration agreements you're going to enter, and who owns what. Those are things you want to understand, not something to be concerned about or afraid of, but understand that, to the contrary, understand the need to do that, and just make sure everything in terms of your agreements is buttoned up. Research, development, and protect. Very important that we're thinking about how do we protect what we're developing along the way, whether it's patents or whether it's trade secrets. Should I patent it? Should I keep it secret as a trade secret? And how do I do that? Business strategy will change. This is similar to number one, keep open doors open. Be flexible, revisit your IP strategy. And if the current strategy is relevant, bi-monthly, maybe even monthly, think about how your technology in particular is progressing and what direction it's moving with respect to your current corporate vision and the current trajectory of your company. Here's a couple tips. Again, there's a lot on this slide, but hopefully it'll be a good reference going forward. The main takeaway here is communication across all channels within the company, whether it's a small company of 5 people, a larger company of 50 people to 300 people to 1,000. What's important is that you've got communication across all different business units. That's what I've seen be most effective in terms of aligning your intellectual property with your corporate strategy. This last bullet on the left, effective communication requires consistent use of company nomenclature across all business units. So the IP team is talking about the technology, talking about the market, using the same words that the business team is using. The company should have a common lexicography from day one. Then everyone knows what everyone else is talking about. This slide says, turn company vision into a patent strategy. Demonstrate your innovation. Routine patent applications filings can serve as the building block of a successful IP portfolio. Size and strength of the portfolio is a guide for investors to value the company, something we haven't talked about a lot today in terms of company valuation, but a strong, robust patent portfolio, and we're seeing even more so a strong and robust registry list of company trade secrets. Investors, in our experience in the past 2 to 3 years, are looking at trade secrets just as much as patent assets in terms of how they're valuing a company and what kind of money they're choosing to invest. Build up defensive assets, very important. Patent is a sword and a shield. A patent portfolio does more than allow you to exclude others. It deters competitors from filing suit. Patents are trade secrets. We've already talked about this. The balance, how to strike the balance. It's really a company specific analysis where you look at the risks and benefits and what the specific technology is and what the market's looking like. And we're going to wrap up by talking about risk assessment and mitigation. Now, what do I mean by that? Well, first, there could be inbound risk, mainly patent litigation, which none of us want to have to deal with. It's expensive. It disrupts the company, it disrupts the business, but that is something that we all know can happen. It can result in damages, attorney's fees, and injunction, which is very rare these days because of the eBay case in 2006, but it can happen in off occasions. Trade secret misappropriation is actually growing. We're seeing a lot more of that. New employees, and that's we're seeing that in two contexts. We're seeing employees that companies are hiring accidentally or maybe intentionally bringing trade secrets from their former employer with them, and the new company being sued for that, for misappropriation, because they hired an employee that misappropriated and brought with them trade secrets. We're also seeing the opposite, where you have employees leaving, offboarding a company, and taking proprietary information with them to their new employer. So we're seeing it going in both directions. Here's a term some of you, maybe many of you have probably heard or seen: freedom to operate. Now, what does this mean? This means if I set up my company, if I go to market with my product or my service, am I infringing someone else's intellectual property? Am I going to get a cease and desist letter? And this relates to the previous slide about patent litigation. So there's different options here. One option that companies can take is to have a freedom to operate assessment or analysis performed, where a patent lawyer would look at other patents that are existing out there and owned by third parties and see how those relate to what the company is currently doing. If there's one or two or three or four or five patents that are problematic, you always have the option to license those patents. You could try to design around the patents, change your service, change your product to avoid those patents. This next slide is kind of a high level process flow of how we do freedom to operate, or FTO, analyses internally here at Mintz. Establish and maintain privilege. This is important, and it's a very good way to mitigate risk. And that is, if there's chatter inside the company about a potential third party having a patent that could be problematic, keep those communications to a minimum and try to talk to legal counsel about them, because that shields the communication, that shields the written concerns with the attorney-client privilege. So if the work is performed by company personnel outside of the advice of legal counsel, it can be discoverable. That means if there's litigation that ensues, then that could be produced and shown to the other side, which could be detrimental to the company's position in the case. Have outside counsel perform the FTO diligence to protect it and shield it with that attorney-client privilege cloak. And lastly, insurance. We're actually seeing more clients, companies taking out insurance relating to IP. There are costs associated with patent infringement. There's costs associated with trade secret misappropriation. That can just happen. It's part of being a business. And we are seeing IP related insurance policies being bought more and more. And there's companies that are creating policies specifically for IP litigation, patent infringement, trade secret misappropriation. So there's a lot more products out there in the market than there used to be. And they can be affordable depending on how large the policy is. And lastly, as I talked about a couple slides ago, design arounds. The best way to deal with a problematic patent, for example, is to change the design of your product within reason to avoid the claims or the scope of that patent. And that will wrap it up. Can I answer any questions?
Awesome. We've got one more that popped up. Alan asked, would you copyright a trade secret? An example is a taxonomy of the world economy in terms of a list of 24,000 industries. Issue, if any country in the world doesn't help protect the copyright. It took 40 years to develop.
So good question, Alan. If you copyright trade secret, it becomes public. So it would not if that that would be a problem. It would no longer be a trade secret because you have to file it with the U.S. Patent and Trademark Office. In term, let me taxonomy of the world economy in terms of a list of 24,000 industries. I don't know if you get a copyright on that either. That might fall under the list of facts or recipe type. That might be challenged. That's an interesting question. Issue, if any country in the world, China, for example, doesn't help protect the copyright. It took 4. That's true. I'm not too conversant in Chinese copyright, admittedly. China's just starting to come into the scene on patents and actually trade secrets more than anything. They if you Google trade secrets China, you're going to see a lot of interesting stuff. Copyright, I don't hear a whole lot about. I don't even know if they have a formal system. I would imagine that they do. It's not something I deal with in my practice.
Any tips you can suggest if you know it only takes about 2 minutes to steal 40 years of work? Anything you can suggest?
So what's your specific issue or a specific example? You have a list of something, or what exactly do you have?
It's a list of the global economy. By the way, I want to applaud you not only for the presentation, but very few people would put the term business unit down. So the difference between a business unit and a company. So we answer a very basic question. What business units or what industries is a company in? And we use the word industry at a very granular level. So a company like PepsiCo, we have 157 industries that they compete in. So that's
Oh,
the
wow.
one.
Okay.
So that's the one thing we do. So most people are familiar with either SIC codes or NAICS codes in the United States.
Right.
That defines the global economy in terms of 1,075 industries. I'm a fan of a guy named Michael Porter from Harvard, and if you do it his way, there are actually 24,000 industries.
Wow. I actually wasn't aware of that number.
Well,
So to get back to your question, you have a taxonomy of 24,000. Oh, I see that's what you wrote here. 24. So Michael Porter came up with that.
it's his methodology of what an industry is. So he wrote a book in 1986 that I read where paper towels and paper napkins are distinct global industries. I used that since 1986 to today, and now there are 24,495 if you want an exact number.
Oh, interesting. So he definitely has a copyright in that book. That's for sure.
He
And the
has a
content
copyright.
there.
He has a copyright on the book,
Right.
and this is a list of saying this is better than the United States NAICS codes, which is really SIC codes developed in 1939. So it's it can be stolen so quickly, and that was the issue. But there are other questions. I don't want to take up too much of your time. So
Thank you, Alan. So I have a question from John. If you have something you want to patent, but you want to beta test it, yes, 100%. Would an NDA protect you prior to applying for a patent? How can you test an idea with users prior to patenting it? So if you hire, good question, John. If you hire a third party, a contractor, a subcontractor, which companies do all the time, to help you test something, 100% an NDA has to be entered, and 100% that will protect you. The big issue with, so there's two things with a patent in particular. Number one, public disclosure. Once you publicly disclose something, you have 1 year to turn around and file it with the patent office. Number two is ownership. You want to make sure that whatever they do, whatever their involvement might have been in the testing, you still own. So you just have to make sure that that's clear. By virtue of entering an NDA, it's automatically not public. And then in the NDA, you also want to have provisions that say anything that you do, beta tester, third-party contractor person, anything that you come up with as part of the scope of this work is owned by me, John, and my company. And it's again, that's all a matter of contracting. It's all written agreement type stuff. One other question, any good books you can recommend for the nano size business to make decisions on the patent process? Let me think about that one. It's been a long time since I've read books like that. But let me I think Shannon probably has your contact information, John. Let me think about that. Ask some of my colleagues, look around, and I'll send you some ideas.
Okay,
We can
thanks.
definitely connect the two of you.
Yeah, and you
Okay.
can also just I mean, if it's basic stuff, I'd be happy just to have a phone call. No
Okay.
problem at all.
Thanks. Yeah, I appreciate it. Good information.
I love helping small companies and giving out free advice. Seriously.
Any other questions before we wrap up? All right, going
Thank
goes
you.
John.
This was fun. Thanks a lot, Shannon. Thanks,
All
everyone.
right, fantastic. Thank you so much, Brad. We really appreciate it. I know I learned a few things today for sure. I hope that this was helpful to everybody that attended. As I had said in the beginning, we'll send out an email with the recording and with Brad's slides just to kind of reference after this. And make sure to connect with us and keep tabs on our monthly webinar series and find out what's up next month. Thank you, everybody, and have a great rest of your day and a great rest of your week.
Thank
And
you.
per Alan's sage observation, I'm going to remove the confidential property footer before we send it out.
Yes, thank you.
All right, take care.
Thanks so much. Bye-bye, everyone.
Bye.